Can the media be trusted to report judicial proceedings accurately? Well, according to this judge, no. So what am I talking about? This is more on this horrible Sarah Sharif case, where, as I mentioned before when I was talking about, there is no such person known to English law as the anonymous judge. Well, apparently now there is, certainly according to Judge Lawrence. So what happened here? The press, a number of press organisations, applied to the court and said, look, we need, first of all, copies of all the relevant judgments and decisions about why this poor girl was returned to her father when apparently there was all this risk. But also we'd like to know the names of the people who made that decision, the social workers and the people involved in that, but also the judge who actually made the decision to, transfer custody. Like I say, we don't actually use the word custody technically in family proceedings, but everybody knows what I mean, to this person. So they've applied to the court and said, no, you should provide this information. And it's a very interesting judgment. It's very novel. And I think the best thing I can do, because I managed to actually obtain a copy of the judgment, is just to quote extensively from it. I'll try and make it as sort of interesting as possible, but I think you actually need to see what the judge said here. And I'm going to be really interested in your comments about this. Because what it's doing is it's weighing up the right to know, open justice and transparency versus safety for the people involved, the social workers and the judge. And what the judge acknowledged, he said, the decision to prevent the naming of judges must be supported by proportionately clear and cogent evidence that the rights and interests of the judges will not just be interfered with them by being named, but that such an interference outweighs the weighty public interest in open justice. Given the extent of derogation from open justice principle, that is actually quoted in the rules. They call it the open justice principle, and they say that's the starting point. But given the extent of the derogation, absent an extant and clear risk to a judge's safety rising from being identified in connection with they call them the historic proceedings, that's all the stuff that led up to this decision, such as would give a rise to a positive duty on a public authority under Article 2 and 3 of the ECHR, the judge's Article 8 rights do not weigh heavily in the balance. So just to break that down, Article 8 is your right to sort of privacy and family life and just, to be allowed to just get on with things and live your life as you see fit. Articles 2 and 3 are the right to life and the right not to be subjected to technically it's torture and things like that, but not to be subjected to threats and risks that fall short of a risk to life itself. So you've got the two competing things there within the ECHR. And this quite often happens. You have to do a balancing exercise. Now, one issue here was, well, does Article 2 outweigh Article 8 or vice versa? And what the judge said here is, notwithstanding Article 2 is the right to life and Article 2 is the right to sort of privacy, the starting position is that effectively we start with a clean slate. Because, of course, the press were coming along and saying, well, actually, our right to publish is our Article 10 rights. There's lots of articles in this. Article 10 is your right to freedom of expression. They're saying, in a modern democracy, and especially when you're looking at judicial proceedings, that should be the starting point. That it should be very hard to overturn your Article 10 rights. And the judge does acknowledge that in this paragraph. But what he goes on to say is, not naming those involved is not an exceptional step. Although not naming the judges is, I accept, an exceptional step. So what he's saying there is, it's quite common in family proceedings not to identify parties. I mean, obviously you don't identify the children involved, and that can quite often have the knock-on effect of not identifying the parents, because obviously you'd be able to identify the child, if you knew who the parents were, if you had that information. We talk about jigsaw identification a lot in media law, where there's lots of information out there, little snippets, and some dedicated person with a little bit of nous and research can probably work out, the full story and who we're talking about. But what they said there is, they're supposed to do risk assessments in family proceedings about potential violence. And they said they didn't actually used to do that because they'd have to do it in just about every case because family stuff can be highly emotive. And it's not just the parties you have to worry about, it's people reading things. And it's this idea that, well, people get the wrong end of the stick And I'll come on to sort of, digital lynch mobs shortly, because that's something that cropped up. But just to go off, and be me for a second, I think this is part of the issue. One of the reasons I do these videos is to sort of comment on the law and try and give a bit of context, because there is this issue now that, media only reports, it's the old, if it bleeds, it leads. They tend to report in quite sensational terms, and they just don't give, the full picture. I mean, you can read an article about a court case, but they'll never link to the actual judgment or anything like that. So it's always coming through with, the reporter's own biases and perceptions. Even if they try to be totally objective, they're bound to make editorial decisions as to, what to put in there and how much. And that inevitably leads to distortions. But he says here, as the media parties have relied on in support of their application for extensive disclosure and publication rights, it is the exceptionality of the case that warrants that level of disclosure and publication. However, the obverse side of the exceptionality coin is that individuals associated with the case will, I have no doubt, be subject to an exceptional level of attention. That attention will, I have little doubt, range from measured commentary, that'll be me, through to rude and discriminatory slurs. Well, sometimes I like being rude, but I don't like to be discriminatory, be rude to everybody. Moving on to vilification, abuse and threats. That, I think, is reasonably certain in the online world, where a virtual lynch mob will readily assembled in the current febrile atmosphere engendered online and fanned by the undermining of the rule of law and the judiciary worldwide, notably in the USA, but in this country also, where a headline identifying senior judiciary as, quotes, enemies of the people, unquote, was seen as legitimate comment. So there you go, the judge getting a little bit of politics. So the judge there is saying, well, forget how we used to do it in the old days, now with all this online stuff. And the judge did go on to say, look, in the old days, cases were just reported possibly in the local newspaper. And that might provoke a few sort of angry letters to the editor, and maybe people might get recognised in the streets. But there wasn't this sort of thing where, you're suddenly exposed to millions of people who can all comment, and you get a sort of big whirlwind on Twitter of people sort of, putting their own opinions in, not always, the sort of best informed opinions. So that's the flip side. So the judge is saying, we have to balance people's safety. But what he recognises there is we've always protected, the social workers, because they're just people doing their job. Of course, the counter argument is, well, we need to know how well they are doing their job. And who is making these decisions. But anonymity for witnesses, because in proceedings like this, social services, CAFCAS, all those sorts of people, they are just witnesses. Yes, they have they are professionals, but they're not professional witnesses. They just come to court to assist. And in the same way that in a sort of criminal trial, we'll quite often grant anonymity to witnesses if their identity isn't an issue in the case. Well, so yeah, you can come along and you can give court evidence anonymously, you can do it from behind screens, because we want people to come across and be as uninhibited and frank as possible. And that's what they're saying here. It says, if social workers are going to, not cover, do the old CYA thing, because the argument is, well, if social workers are going to sort of get vilification, they might just take the safest option and just go, you know what? Notwithstanding what decision I think is correct in this case, that's the one that will get me lots of stick. So I'll just play it safe. And that might undermine, what is in the best interests of the child. So the idea is that, they should be able to speak freely without fear of sort of, getting harassed or threatened online. And just give some examples. It says the likely level of online abuse will be high. However, the reality currently is that in addition to that, there is a real possibility of some individuals going further, much further. The BBC reported only last week on a case of a man who attacked a firm of solicitors identified in the Daily Mail as being involved in processing asylum applications. Hotels housing asylum seekers were firebombed. That is not to make the press responsible for those actions, of those who perpetrated such acts, but putting names and faces in the public domain bring with it potential consequences from those who are unstable, aggrieved and fanatical. Attacks upon those in authority by those with grievances have led to D-word, Joe Cox, and serious assault, Judge Perusco, that's a judge who actually was attacked recently, arson on the home of an expert witness, although the perpetrator accidentally firebombed the neighbour's home, and stalking of judges. So, you know, there are real consequences there. And he says, in my role, this is Judge Lawrence, in my role as family presiding judge of the South Eastern Circuit, I and the other presiders reviewed security threats to judiciary on a regular basis. Abusive and threatening communications, threatening and abusive behaviour in court, stalking and online abuse are regrettably a growing phenomenon, to the extent that judicial security in the aftermath of the assault on Judge Perusco have been subject to extensive review. And they go on to talk about actually, you know, all the risk assessment and the threat assessment stuff. They said, they did a survey, 27% of salaried judges were concerned about their safety in court. Okay, that's very subjective. 19% about safety outside court, 8% relating to social media, and overall 54% were concerned about the personal safety of judges, and 83% were concerned about attacks on the judiciary in the media. So, you know, there is this, but, you know, as I've said before, you know, you're not conscripts. You don't get sort of press ganged into being a judge. However, the judge addresses that point. He says, being subjective to abusive behaviour is not a part of our job. For the senior judiciary, we accept that we are in the public eye and we apply for the role knowing it will involve cases of the greatest public interest and accompanying scrutiny, and being identified is part of that territory. For magistrates, the district and circuit bench, that is not part of their expectation. The case, when it was before the family court, then it gives all the relevant dates, was not exceptional. It has become exceptional because Sarah was M-worded by her father and stepmother. I do not accept the connotation based on Leavenger's observations. So this is a judge saying, actually, you know, tough, I'm sorry, we're going to name everything here. That judges, experts, social workers who work in child protection and the family justice system are by that fact in a category who can and should be identified in reporting. A discretion undoubtedly exists to name or not name them. But it's interesting there that the judge is saying, well, I don't care. Other judges have made this point that, look, it just comes with the territory. However, you know, as a senior judge, I'm saying it shouldn't have to come with the territory. So it says, it will be of no comfort to those named if the risk comes to pass that it was a small one. Who willingly would accept a risk of serious assault or worse? The impact of individuals of being named in relation to such cases is vividly captured by Lisa Arthurworry's account following Victoria Climby's death. She was cleared of any misconduct, actually, and she was. They looked in and said, this wasn't your fault. But that didn't happen until 6 years afterwards, you know, how slow these things were. And she said, I had expected to be suspended from my job, but what absolutely killed me was being placed on the Protection of Children Act list. You know, that's the one for people who, you know, shouldn't be allowed near children. Now I was a child M-worderer who had become a P-word, almost rhyming with culvert. If I looked in the mirror, I didn't see Lisa, just the other P-word, you know, the one we're always talking about, the PDF file. In the September of the same year, I was sacked and referred to psychiatric service. I couldn't remember my past. She ended up on antidepressants, alcohol, you know, she was self-medicating, and her weight dropped to 5.5 stone. Whenever I left my flat, all I could see was red, the colour I associate with Victoria in that kilt and jumper. By now it was clear I was having a breakdown. I spent 5 weeks in a psychiatric hospital, and when I came out, I began tentatively to get back in the world. Now, she was ultimately cleared. They said, yeah, you didn't do anything wrong. But the argument is she'd been named and identified, and she was being vilified in the press and by the public, and she was just scared for her safety. So the judge says here, like, you know, the exceptionality of this case, we're talking about the Sharif case, and it is really exceptional even within the confines of appalling child M-words and the highly charged emotional responses which will accompany it, understandably may readily go beyond online and intrude into the real world that judges and the third parties, the social workers, live in. The judges and social workers have their own Article 8 rights, which are not to be infringed, unless that is a proportionate infringement justified by the full upholding of the Press Article 10 rights. The evidence set out above establishes a clear and imminent risk of serious infringement of the Article 8 rights of all the third parties, including the judiciary. I do not accept the submission that evidence needs to be individual specific. In other words, you don't have to sort of say, yeah, well, here's a specific threat about a specific person from another specific person. It's like you can just look at the general atmosphere. So he goes through all this and he says, I don't disagree with any of the dicta relied upon by the media in support of their arguments. Although in respect of the accountability submission, I do not believe that the media parties seriously suggest that there is no difference given to the weight to be given to accountability points depending on context. Given that the range might be from egregious misconduct through to exceptional diligence, there plainly would be greater weight in favour of identifying someone guilty of egregious misconduct, which would readily place all but the most powerful Article 8 rights, but probably not Article 2 rights. In other words, there's more of a public interest in reporting when people get things wrong than just reporting when people just do their jobs and there's an argument as to, there's an unfortunate outcome. Because, we've not really looked into, and this is why they've asked for and been given all the stuff about the actual decisions that led to this, because we've heard it was a very inexperienced social worker, but there's evidence that actually the information provided was that it was other people who were a danger to this child and it was probably safer to return. The poor little girl herself said she wanted to be with dad because, she said, dad and stepmom don't hit me. So it's like, right, we'll take you away from the people who do. I mean, this poor girl, it just seems that everybody, I won't say let her down because it went far beyond that, but it's really horrible to read all this. I mean, this is another thing just to talk about, the effect on the judiciary. And there's no counselling for judges or lawyers when you do these horrible cases and you're faced to them. I mean, when juries do horrible cases and have to rule on this and hear lots of evidence and see photographs and, hear tape recordings of things that are just, nightmarish, they are actually given counselling, but judges and lawyers were not. So that's the balancing exercise. And what the judge has said here is, in looking at all these competing rights, then it comes down on not naming the judge or the social workers, because the argument is, what more do the press need to make their decision? They can say this was a failure and this was a terrible decision, but does it make any difference to identify the people? Because what's the purpose of identifying the people? To name and shame them. The argument is it can all be dealt with internally, and I can see why people say, well, no, because we want to know what's going on. We need openness and transparency. But the judge has done the balancing exercise here. He's also made a point, actually, about accuracy. And he did a little snarky dig. And he said, even in this particular case, he said the relevant journalists in this case, especially The Guardian, he said they actually misreported just these procedures. He said they have argued and said, I refused leave to appeal in this case. I said I hadn't at the time, they'd only listed it, and I said, okay, we need to consider this, we'll adjourn it for this argument. So he said that in itself was a misrepresentation of the facts, and this was a case they were involved in. So if they can't get the facts right of a case they are involved in and they were present at, how can you trust them to get anything else correct? However, that's not necessarily the end of it, because what he says is decisions on naming or indeed any other aspect of disclosure and publication are not set in stone forever. The grant of anonymity to an individual is likely to be based on dynamic factors which will change. What is the likely risk at the time of verdict or sentence as the hurricane approaches may change after it has passed, and then a different and perhaps better and differently informed decision will be possible. So he's saying, I would not name any of those involved without inquiries being made of them as to their health and response to potentially being named. Because the other thing is, they said they didn't put on notice any of the people that they wanted to talk about. They made this application and the judge is saying, well, we haven't heard from any of the people you want to name, and it probably is important to see what their view is. The consequences could be devastating for them emotionally already, quite separate to any consequences of emotional and physical to the fact of having their name placed in the public domain and linked to being responsible in some way for Sarah being in the care of her mother and stepmother who M-worded her. And I'm sorry to use these euphemisms. I know they annoy people and they annoy me, but it's just the way the algorithm works. And it's strange because sometimes I can get away with saying all sorts of things. I mean, it seems apparently where YouTube's it monitors the first bit of your video, and then once you get home on that, then towards the end of it, you can sort of say what you want, and it doesn't seem to care. But I just don't want to risk it. And it says, none of the third parties who might be named were given any formal notice of the application, and the possibility of their name appearing in headlines, along with the likely assertion that they bore some responsibility for her D word. Nor would the judges have been aware. No inquiries have been made as to whether anybody who might by default have been named had any vulnerability or other particular Article 8 right, which they might wish to put forward in support of the claim for anonymity. In future cases of this nature, it would seem wise to identify these points in advance and to give notice of the parties to the parties that the press wish to name, so they can themselves be notified. And basically, what he's saying is, we can revisit this. And he's actually said, we'll come back in 3 months' time, and we'll see if calmer heads have, if people have calmed down a bit and there's more information out there and people have a better picture than just the immediate aftermath where everybody's sort of like, very angry and not necessarily open to reason and, reasoned discussion. And it says, the responsibility for Sarah's D word lies on her father, her stepmother and her uncle, not on social workers, child protection professionals, guardians or judges. So he said, I'll list this in 3 months' time, and you can all come back and you can argue it again. So there you go. So like I say, in summary, lots of competing, ECHR rights there. Article 10, your right to freedom of expression. Article 8, your right to privacy and security. Article 2, your right to life. And Article 3, your right not to be subjected to degrading treatment. So it's all in the mix. There's also something called Article 17 that says you cannot use one article, one right to undermine the rights of other people. So this is all very sort of, ECHR sort of interesting debate. But there you go. I'll see what happens here, and I'll keep an eye on this and report back. But yeah, I'll be very interested in the comments, on what you think. I mean, should it always be, no, I'm sorry, we always name you. Should there be a difference between naming the judge and naming the social workers? Should everybody be named? Should it be, fact specific? Should it be, well, we'll generally name them, but we won't name them if they're a particular threat? How far do those threats have to be? Can you just take up with a bit of getting sort of criticised on Twitter versus somebody hiding in the bushes outside your house? Let me know. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. Oh, I should say Happy Christmas. I'm recording this on the 22nd. I mean, I don't know if I'll get any videos up. I'm not a big Christmassy person, to be quite honest. So how are you spending your Christmas day? I'll probably be just in some wood somewhere doing a video, assuming the weather's nice. But yeah, if I don't see you before then, happy holidays. I'm not just saying that to, annoy people who do that. I'm just covering all my bases here. So happy Christmas, happy Hanukkah, happy Yule, happy solstice, however you like to celebrate. I hope you and your loved ones have a either festive time or a really chilled out time. I'll be perfectly frank, for Christmas I just sit there and do nothing. I used to be like out with friends and partying and everything. But I'll just catch up on Christmas reading, although as my Christmas reading is actually libel checking a book. This is like, does this job ever end? And just to sit here, oh sorry guys, I'm just going to be blanking you out. But there you go. So I'll take a picture, look down, look up, look that way. And I probably, like I say, my last thumbnail I did myself. I didn't ask Dan to do it, and I noticed it's one of my worst performing videos. So I think again, I might be asking Dan to do this one. But I did think of a title in advance, so if I use it, you'll see it.